Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 182 of the NCDWI Guy podcast. On today's episode, we are talking about a law that took effect last week, the Pretrial Integrity Act, the impact that has on DWI cases. A relatively brief reflection on this because it's kind of a proof in the pudding type situation. But we're going to be kind of going over that because I do think it has a pretty major impact on the DWI front. Very excited currently, not necessarily about this particular law, but I have been putting the finishing touches on the inaugural Freedom Fighter Summit that we'll be hosting next week. And super excited about the summit, the group of lawyers that is coming, the admin teams of the law firms attending, the group of speakers that we have, the content that is come together for this, some of the exciting, entertaining aspects of the conference that we've been putting together. It's just been a blast working on this thing, and I am super, super excited to launch Freedom Fighter Summit 2023. So if you have not signed up, you're going to miss out if you don't come. It's going to be amazing. The leaves are changing in Asheville. It's beautiful. We've got the cool fall weather. And if you're hungry to learn, if you're hungry to get after it, if you are ready to be a better leader, if you're ready to up your branding and marketing, if you're ready to give your clients a better client experience, if you are wanting to improve the culture of your team, if you want to be more impactful in your community, don't miss out on this summit. It's going to be amazing. So diving into today's episode, we are talking again about the Pretrial Integrity Act. This act took effect on October the 1st. The School of Government has put out a couple of good articles on this front. So if you want to type in Pretrial Integrity Act, SOG, into your Google search, go get some information from the School of Government, some good information there. But basically, this law certainly deals with a whole laundry list of crimes and when, if at all, a magistrate judge can set bond on felony cases, on certain types of misdemeanor and traffic cases. So it is a pretty major change when it comes to magistrates' authority, or really at this point, kind of lack thereof, to set bond during an initial appearance upon somebody being arrested and taken to jail. But the big deal for us on the DWI Guy podcast is the impact that this has in the arena of driving while impaired cases. And what the act says is that if a defendant is on pretrial release at the time of arrest for DWI, so if the defendant is on pretrial release, doesn't matter what they're on pretrial release for, if they're on pretrial release, they get a DWI charge and they are taken in front of the magistrate. The magistrate cannot issue a bond or set a bond for the first 48 hours. That during that first 48-hour time frame, the only judge that can set a bond is a district or superior court judge, but generally a district court judge is the only judge that can set a bond on that particular type of charge. The magistrate does not have authority within the first 48 hours. So some things to look out for in this arena. First of all, is your client actually on pretrial release? Are they on pretrial release? If so, the law potentially applies if they're charged with DWI. If they're not on pretrial release, the law doesn't apply. So if you have somebody being held on a DWI more because of this law, but they're not on pretrial release, then that is certainly a statutory violation. They've got to actually be on pretrial release for some offense for the law to take effect. The other big thing to look out for, and I think that this is really where this case is going to go to be litigated, is how does this conflict with Knoll and its line of thought? You know, that basically a person charged with driving while impaired has a minimal window to basically be able to prove a lack of impairment, to be able to get access to their own meaningful access to their own witnesses and tests. If you are being released from custody 48 hours after you're charged with DWI and you immediately go to your friends and family and ask them to kind of observe your condition, you immediately go get a blood test, it is basically meaningless. It is effectively not helpful to have that evidence at that point that could be used in defending the DWI case. So this requirement to be held for 48 hours really stands in contradiction to the idea that a person charged with DWI under Knoll really should be released as soon as practicable so that they can have the opportunity to defend themselves, so that they can have the opportunity to seek their own witnesses, obtain their own subsequent testing. That's what the Knoll case law says is required, and that's where the violation occurred in Knoll, is that there was a lack of opportunity for a defendant to go and actually get their own evidence that could be used in their trial to defend themselves. So again, DWI is a different type of beast than many of these other charges. If you are charged with if somebody's charged with assault, if somebody is charged with larceny, if somebody is charged with a drug violation, there's really not some sort of like generally, at least, for the vast majority of cases, generally some evidence that needs to be obtained immediately in order to defend yourself against the case. And by immediately, I mean like right now, like at this particular moment of time. That's what is so unique about a DWI case, is that you have state actors, police officers, potentially a magistrate or somebody else associated with the state. You have state actors that are basically telling the judge ultimately at trial that your client was impaired. And the only way, or not the only way, but one of the best ways to defend against that type of allegation is to show, no, I wasn't impaired. And the only way to do that is to get evidence quickly after the charge occurs, because that is going to be the only time frame that is relevant for purpose of proving sobriety or proving a lack of impairment. So this is something to really keep your eyes open for. Again, go do a little bit further digging and researching. I think we're going to see some interesting issues pop up on this front, particularly in the DWI context. I see this as really being a burden on district court judges. This is one of those laws that I just kind of wonder for the people that are kind of discussing these things, how much information is presented about how many cases or how many charges are brought in front of magistrate judges and bond set, because this is really, to me, going to create a humongous burden on the district court judges. I mean, it's where they're the only ones that can set bond, and magistrates really are handicapped in terms of the conditions of release that they can give during an initial appearance, whether they can set bond or not. This law really takes away a lot of that discretion from the magistrate's hands. And I think we're going to see a pretty heavy burden placed on our district court. So we'll see how this plays out. If you have an interesting case along this framework, I would love to discuss it. So give me a call. Please reach out. I'd love to talk through it. But hopefully this information has been helpful. Again, go check out those School of Government articles. And I look forward to speaking with you next time. For those of you attending the Freedom Fighters Summit next week, look forward to seeing you.